All right, hello and welcome back to the Carl Jackson Show. I am now joined by my guest, Amy Swearer. She is with the Heritage Foundation, and she's a senior legal fellow there, and she wrote a column for the Daily Signal entitled "Debunking Four Big Errors Made in a Lawsuit to Stop Trump's Birthright Citizenship Order." And I want to get into this. You guys know that on this podcast, and also while I've been sitting in for Dennis Prager, I have been harping on this issue. This is totally insane to me. This seems like common sense. And so we're going to have Amy break it down. Amy, welcome to the Carl Jackson Show. Thank you for taking the time to come on.
Hey, thank you so much for having me.
Absolutely. Okay, so this seems obvious to me, Amy, but here I'm not educated. I mean, I'm a high school graduate. I'm not a college graduate, but I have read the Constitution. I have read the 13th, 14th, 15th Amendment, and I could have sworn that the 14th Amendment applied to the children of slaves. But
Right.
apparently the left says that I'm wrong, and I want to get your take on this. This is just crazy to me. And if you were explaining to me offline, we've had yet a second judge come in and I guess impose an injunction against the Trump administration in his executive order to end birthright citizenship. Will you talk about that, and then we'll get into your column?
Sure, absolutely. Yeah, I mean, so on the one hand, it's really not, if we're being honest, unexpected. One, that you had a number of states and organizations immediately file suit to try to stop this new executive order from going into effect. But I also think it's not necessarily surprising that you're seeing judges, at least this early on, basically agreeing with those states and issuing what's called an injunction, basically stopping that order from going into effect. And I think this really
Okay.
comes back down to, and I know we'll get into this, but for a lot of people in the legal world, at least, Trump's order comes across as shocking, right? Because we've had this sort of standard prevailing model, this theory in the legal realm for probably the last 70 years that's
Wow.
been unquestioned, that essentially says birthright citizenship is for everyone. It reads out an entire clause, an entire phrase of the citizenship clause that's really important. And so it's not surprising to me that you're just seeing judges sort of rubber stamp these injunctions because they've never been forced to really seriously consider whether this prevailing model, this prevailing theory is wrong. And I think it is.
Huh, that's interesting. So it's not necessarily, as I assumed, frankly, if I'm being honest, Amy, that, okay, they hate Trump. Anything he does, they're going to try to stop because they're left-wing judges, maybe. This is something like, as you said, nobody has done anything, moved the needle at all for 70 years. So, again, this is to be expected. So if I'm a conservative, obviously, and so it's not just necessarily get Trump.
Right. So I mean, it could always be both, right? But I
Okay.
think really what this comes down to, and even amongst a lot of conservatives, you're seeing sort of the shock of, well, how dare you question this universalist theory of birthright citizenship? But again, when you get into the history, that was not always the case. This is a sort of modern prevailing theory that's very different from what the people who drafted and ratified it understood it to be at the time. And that's all that Trump is trying to do, is to take it back to that original understanding and it's interesting to me that it's not just you, it's a number of people that you talk to. They say, well, that's common sense. Of course, it doesn't universally apply to everyone. Why would anyone do that? And that's, I think, the correct legal argument as well, is they didn't do that.
Okay. All right. So let's get to debunking this stuff. You laid out four big arguments here. And hopefully, again, I mean, this is for all of you that are listening and tuning in to the Carl Jackson Show. Again, we're speaking to Amy Swearer. She's a senior legal fellow at the Heritage Foundation. She's an attorney, obviously. All right. And so the first error you talk about is the citizenship clause merely adopted the pre-Dred Scott common law rule that everyone born in the United States is automatically a citizen. Talk to us about that, please.
So I know that was a lot of legalese there, but let's break this down. Right? So you go back to our original Constitution, there's no definition of citizenship. Right? It talks about citizens, but it doesn't tell us who is or is not a citizen. And prior to that, you had this English common law that's known as jus soli. It's based on these feudalistic principles that sound pretty ridiculous to us. It's this idea of if you're born in a place, and there's a sovereign, a king over that, you owe that king, just by virtue of being born there, perpetual allegiance. Basically, you will always be subject to the king under which you're born, and you can never leave that. And that's pretty incompatible with a lot of what the American Revolution was founded upon, right? Governance by the consent of the governed, compact theory, consent of the governed, right? And then basically, So what happens is we have a uniquely American problem that arises because of slavery, where in 1857, you have the Supreme Court holding in this infamous case called Dred Scott that the U.S.-born descendants of African slaves are not citizens. They can never be citizens, even though under this traditional common law rule, right, of course they'd be subjects, but they'd be citizens. So we've created the scenario where these people can never be citizens because of their race. And so what Congress is doing in the 14th Amendment is they're trying to deal with a very specific problem that we've created, where we've said certain people, because of their race, will always be aliens in the land where they're born and raised and die, where their kids are born and raised and die, in a way that we wouldn't if those individuals were white. So that's sort of the situation that the 14th Amendment is trying to address. And the first time that Congress tries to fix this is through the Civil Rights Act of 1866, right? And the argument goes from universal birthright citizenship advocates today. They just say, well, what Congress was doing to override Dred Scott was they were going back to this English common law rule, right? They were correcting Dred Scott by saying we're all citizens because of this idea of jus soli and perpetual allegiance. But the problem with that is that when you read the debates, that's not at all what they're doing. They're not doing that in the Civil Rights Act of 1866, which is actually the first time we define citizenship. It says there that all persons born in the United States and not subject to any foreign power are citizens, right? Which is very different, right? Because now we're talking about this concept of allegiance. And I think this is very clear when you read the debates. They're not talking about the English common law of everybody born here is a citizen. They have a specific understanding of this. And in fact, at certain points in those debates, they tell us we don't mean the English common law, right? And so what they mean is that they are trying to create citizens of people who, like the freed slaves, don't reasonably owe allegiance to any other foreign power. I mean, think about it. You have generations of African descendants who have been slaves in this country for 4 or 5 generations. As one of the senators puts it at the time, he says, are we really going to say that they are the subjects of some African potentate? No, they belong here, right? We wouldn't question this. And so they're trying to encompass this group of people who, like the slaves, irrespective of their race, are here in the United States and owe complete allegiance to the United States government. They don't owe some allegiance to any foreign power. Which is far different than, again, this common law idea of if you're just here, well, you're our subject if you're born here just by virtue of the fact that you're here.
Okay. So here's my confusion, Amy. We just have 2 minutes left in this block. Where did this modern interpretation originate from? Where did this come from? All of this confusion, seemingly.
This really is something that develops in the early 20th century. And so now we're talking about 60, 70 years after the 14th Amendment gets ratified. And it really just happens because of just practice, executive branch practice. You do have a Supreme Court case in 1898 that people will talk to or talk about. And I assume we'll get into that, but it doesn't actually hold, as the advocates today will say, that, well, the Supreme Court settled this. It said all people born here are citizens. It didn't do that at all. It was much more limited. But as a result of that, you do start to see, just as a practice, the executive branch, the federal government, treating everyone as citizens. And after a while, if you start doing that, people stop questioning it. they start developing this narrative of, well, everybody's always believed this the whole time. And
Wow.
really what they've
Wow.
done is they've lost track of about that 40, 50, 60-year period after the ratification of the 14th Amendment, where actually nobody thought that. Basically, everybody agreed that if you were born here, you were only a citizen if if your parents owed a complete allegiance to the United States, which was often tied in with, and you see this in Trump's executive order, your parents could be not American citizens, but they had to be lawful permanent residents here because that was seen as the first step towards severing your previous allegiance.
Okay. All right. We've got 30 seconds left in this break. So I think you're talking about was it the one Kim Ark decision? Did I get the right name
You did.
there?
You did.
Okay. Okay. So what we'll do is, again, we're speaking to Amy Swearer. She is a senior legal fellow at the Heritage Foundation. Actually, Amy, too, I've read you for years. I've loved your work on 2A as well. So it's an honor to have you on. We'll be right back. More with Amy Swearer of the Heritage Foundation. Stay tuned. Hey, Carl Jackson here for My Pillow. For years, customers have been asking if My Pillow sells cross necklaces like the one Mike Lindell proudly wears every day. Well, they are excited to announce that Mike has partnered with a jeweler right here in the USA to create beautiful sterling silver My Crosses. You can save 30% today using promo code Carl. That's CARL at mypillow.com. Click on the radio podcast square or call 800-858-0263 and be sure to use promo code Carl, C-A-R-L. We don't spell it like the communists. All right. So you can choose from the women's or men's style. The My Cross for women has a more delicate look and is reversible with mother of pearl style translucent white enamel on one side and onyx styled black enamel on the other side. The My Cross for men has a slightly larger cross with onyx-styled black enamel and a slightly longer, thicker chain. This amazing offer won't last long, so order now, por favor. Just go to mypillow.com, click on the radio podcast square, or call 800-858-0263. Use promo code Carl, C-A-R-L. All right, welcome back to the Carl Jackson Show, your daily dose of objective truth in a world of confusion and lies. Again, I am joined by my guest, Amy Swearer of the Heritage Foundation, a senior legal fellow there. And she's debunking the birthright citizen debate. Obviously, plenty of people, I want to say that are, I was going to say on the left, but I don't know if that's the right word to use, but plenty of people that are advocates for birthright citizenship believe that, listen, if a child is born here, whether or not their whether or not the mother or the parents are residents or citizens, I should say, in the United States of America, their child is an American citizen. But that's not the way it was intended. That's not the way the people of the time when the 14th Amendment was written interpreted it. And Amy, let me ask you, when the 14th Amendment was written, didn't they take language from the 1866 Civil Rights Act to make it clear?
So this is actually one of the arguments that sort of proponents of universal birthright citizenship say, right? They say, even if whatever the Civil Rights Act of 1866 may have said about being subject to a foreign power, well, look, right? The 14th Amendment doesn't say that. It says just subject to the jurisdiction of the United States. And so it means something different. Clearly, they're adopting the common law. Well, one, again, you read through the debates, they clearly Congress understands that they're doing the same thing, right? That it's almost two sides of the same coin, that people who are subject to the jurisdiction of the United States are simultaneously not subject to any foreign power. So they think it's the same thing. And they change that language basically because they're trying to figure out how to better apply that to literally tribally affiliated Native Americans who aren't technically foreign powers. There's sort of a weird dynamic there. So all they're really trying to do is to restate more clearly the same thing. And you see this in these early commentators who are talking about what this means, because nobody at the time thought that what they were doing was making citizens of literally everybody born here. They clearly understood that there was we'll call it a jurisdictional element, an element of allegiance, that it's making citizens, again, of people who, like the newly freed slaves, owe complete political allegiance to the United States, that they've severed any tie of allegiance to a foreign power or some other power that they have. So that's really what this is about. And you start to see this as well. You're getting into point number 2 that I make. You'll have people say, "Oh, well, this is the first time the executive branch has ever tried to limit it to this narrow definition," and it's just not true. I mean, you look at the decisions in the executive branch throughout, basically up until the 20th century. They're doing the same thing that Donald Trump is doing. You have decisions by the Secretary of State instructing officials, do not give passports to this man who was born in Ohio. Right? We all agree he was born in the United States, but he was born to German citizens who never became U.S. citizens, never wanted to become U.S. citizens, who took him back to Germany and raised him as a German. And so they're saying, yeah, he was born here, but he wasn't born subject to our jurisdiction. He was born subject to the German authorities. And so this idea that Trump is doing something just insane and unprecedented, no, you go back to those first several generations afterward, and you told them today that we've just been issuing passports to everybody, they'd be more confused about that.
Yeah, Amy, and this is such an excellent point. And again, you can make sure you check out the column. Actually, I'll post it with along with the podcast. But debunking 4 big errors made in lawsuit to stop Trump's birthright citizenship order. I mean, but this just makes so much. Again, I mean, to me, this seems like common sense, but obviously, I guess it's not so. I don't know. This is just weird to me. But again, it's not unprecedented. Secretary of State, you mentioned here, has done this before. Let me ask you this: is there any other country in the world besides the United States that is dumb enough to have birthright citizenship?
No. Well, and here's the irony, right? So this idea of universal birthright citizenship comes, as at least the theory goes, that we inherited it from the English. It was part of our English ancestry, and we just adopted it. Do you want to know who doesn't do this anymore? England.
Of course. Wow. Okay.
Nobody does this to this extent, because they've all recognized that this is based on feudal principles that are just insane to us. That you have no right of becoming a citizen anywhere else. You're always perpetually subject to wherever you're born. Just by that's insane, and nobody else thinks that way today. And they certainly didn't think that way at the time of the 14th Amendment.
All right, Amy, I got to ask you, and we'll get on to error number 3 and number 4. We've got 5 minutes left. You're obviously, a brilliant woman. I expect that people you come across in the courtroom that have a different philosophy, legal philosophy, especially on this particular issue, they're not dumb people. Do they really believe this stuff, in your opinion?
So honestly, do you know what this reminds me of? And I know you brought this up offline. This reminds me of the Second Amendment for a long time in the legal world. So if you go back to prior to a 2008 case called Heller, the Heller case, right, where the Supreme Court first weighed in, you had a lot of really smart people in the legal world who were in a very similar place, right, with the Second Amendment, where they we never talk about it. Everyone just sort of acknowledges it's a militia right, and we don't, sort of hand wave, don't look any further. And then the minute that you start explaining to them and you start forcing in the courts people to look at the original meaning and what people were actually writing at the time, those threads start to get pulled and it starts to fall apart. And it reminds me of this, where you have a lot of really smart people who, you go to law school. We never talked about this in law school. It's just sort of like, oh, we assume it. We're not going to read the cases. It just don't look any further. And they've never had to. They've never had to have it questioned. And so this idea that, well, hey, actually, for a long time, nobody thought this way is confusing to them. And so I don't think it's because they're stupid. I think it's because they truly have never looked at the evidence, because they've never had to, in a way that we do for so much else in the legal field.
Okay. All right. Okay. Let's get to error number 3. And and I just skipped over it. It's the one Kim Mark decision.
Yeah.
All right. The Supreme Court confirmed in 1 Kim Mark that the citizenship clause automatically bestows citizenship on the U.S. born children of
Yes.
non-citizen parents. We only have just over three
Sure.
minutes, but
I'll,
let's see what we can do here.
I'll do this in 60 seconds. Wong Kim
Okay.
Mark is really easy. Wong Kim Mark's parents, were lawfully present, permanently domiciled aliens. They were the exact sort of category that today we would call lawful permanent residents or green card holders. Their only problem was that under laws at the time, they were not allowed to become US citizens. So you have a kid who was born here to parents who had lived here for 20, 30 years perfectly legally, who was born here, raised here, who tries to come back into the country and they say, you're not a citizen. And the Supreme Court says, and I think rightfully so, yes. And it's very narrow. It doesn't say everyone born here is a citizen. It says
Right.
that the US born child of non citizens who are lawfully present and permanently domiciled, that is, they live here permanently and not just sort of in passing, that person is a citizen. And I think that's absolutely correct under the original meaning. But that does not, by default, then mean that this applies to everyone outside of that subset. Right? That this doesn't mean that it applies to people who are just here temporarily or illegally. That's not what the court held. And that doesn't make any sense if they did hold it.
Yeah, for sure. Okay, the last error. The president's order will leave many children deportable and stateless, which I don't even understand that argument, to be frank. But I'll love to have you tackle it.
So you remember before when we were talking about how no other country goes by this common law rule? And
Right.
that is exactly why none of these kids will ever be left stateless. They all will inherit the citizenship status of their parents from the country to which their parents are citizens. Look, is it theoretically possible that you might have, under some weird confluence of events, some kid who is born, if he can't get US citizenship, like literally cannot get citizenship anywhere else in the world? I have yet to see that case presented. None of these states, none of these organizations have showed me a case in which that would even plausibly happen. And the reality is it's just not almost all of these kids. I can't even think of a circumstance in which any US born child of illegal aliens or temporary aliens wouldn't otherwise have citizenship somewhere else in the world. It's almost absurd to think that that would be the case.
And frankly, I don't believe anyone that comes to this country illegally or even I know there's like this birth tourism stuff that's going on, and these people feel like they're winning the lottery. But I look at these people that are coming into the country illegally, and I mean, I think they know. They know if they go back or if they happen to have a child and they get rejected, or if they, even now with Trump being in with this executive order, that if they have a kid here, they know that their country is going to accept that kid as a citizen. They know this. We only have 10 seconds, but it's yours. Sorry, Amy.
Yeah, I'm glad you brought up birth tourism. I think everyone should look more deeply into that as well, because I think it's been overlooked as part of the conversation.
All right. Amy Swearer of the Heritage Foundation, Senior Legal Fellow, thank you so much for joining us. I appreciate it.